Hi, everybody. Welcome to Keeping Your Trust Healthy, brought to you by the Westhampton Beach Public Library. We're very happy, as Liz said, to provide this information to our community. And I know we're talking to different communities today. People are logged on from all over the place, but we're really happy that Westhampton Beach Library has asked us to do this today. So when we talk about keeping a trust healthy, I think it's important to really start the conversation with talking about what a trust is, because some people might be listening today thinking, do I need to get a trust? And is keeping it healthy going to be so onerous and so difficult that I don't want to go that route? And some people on here might already have a trust and are looking to know what they should be doing and what the upkeep might be. So I'm going to start with this description of what a trust is. A trust is, in its simplest format, a document. It's a document that then, once signed by the creator and the trustee, which depending on the type of trust may or may not be the same person, once signed by the creator and the trustee, it creates a legal entity. And this legal entity can own things. So when we talk about a living trust, which is mostly what we're talking about today, we're talking about a trust that you create while you are alive, and you are what we call the grantor or the settlor or the creator. Those all mean the same thing. It's the person that creates the trust. And the other type of trust, which we're not going to go through today, but I will mention, is a testamentary trust. That is a trust that is created upon the death of an individual through their last will and testament, or in some cases by an individual through a trust document. So if I'm leaving assets to another person when I die, and I'm leaving it to that person in a trust, that subsequent trust would be a testamentary trust. But today we're going to talk about living trusts, which just means you create it while you're alive. Now, there's different types of living trusts. There are revocable trusts and there are irrevocable trusts. And we have different reasons that we create the type of trust that we create. And within the category of revocable and irrevocable, there are a lot of different types of trusts. And all of it really depends on how the document is written. I always like to say that a trust document tells us the rules of the game. So you don't start playing a game of Monopoly without first checking out the directions. That's what the trust document is. It is the item that directs the trustee in how they can behave, what they can do, what they can't do, who are the beneficiaries, who are beneficiaries of income, who are beneficiaries of assets, of principal, what happens upon the death of the creator, what happens if the creator becomes incapacitated. These should all be sections within the trust document that explains the rules of the game. What is this trust? What is it looking to do? And how is it going to accomplish that goal? A revocable trust is a trust that's often created for the purpose of avoiding probate. Probate, without getting into a long discussion, is the process by which a last will and testament has to go through the court in order to be followed. So a will is only as good as the paper it's written on until it goes through this process. So sometimes people want to avoid that and avoid the testamentary trust, the further trusts being underneath the purview of the court. And so they create a revocable trust. And while they are alive, they are and have their mental capacity, they are not just the creator of the trust, but they're also the trustee of the trust. And assets can be put into the trust, meaning you would change the title on an asset to go into the trust. And then the terms of the trust would govern how it was handled. Standardly, in a revocable trust, if I'm the creator and the trustee, I'm not limited in any manner. We tend to use someone's own social security number as the identification for the trust. We don't even assign it a new ID number while I'm still living, if it's my trust. And the idea, again, is to take things from Britt Burner and put it into the name of the Britt Burner Trust. And then that's a revocable trust that's going to avoid probate. There are then irrevocable trusts. And every irrevocable trust is different. And we draft them, we create them, and the powers that are within them and the limitations and restrictions that are within them are created based on what the purpose is. So for some people, they're avoiding estate taxes upon death. For some people, they're looking to avoid probate, just like with the revocable trust, it does that as well. For other people, it's an irrevocable trust that's created so that they can get Medicaid to assist with paying for home care or nursing home care and have the assets in the trust have protection around it. So every trust is going to be drafted and created based upon what the goal of the trust is. So the very first thing, the very first rule of keeping your trust healthy is knowing what you have. Time and time again, we have people who come in and they don't realize that they've created a trust, or they see that they've created a trust, but they don't know what the rules are. They don't know why they have a trust. They don't know what they can or can't do. And the worst thing that happens is that if, especially an irrevocable trust that is created for the purpose of some type of protection or some kind of savings, if you don't follow the rules of the trust, you can spoil the protections that you worked so hard to receive around those assets in the trust. And so knowing what you have is the most important part of keeping your trust healthy, because how could you possibly keep your trust healthy if you didn't know how to do so? And so if there is anyone listening today who has a trust or isn't sure if they have a trust, they should be going to an attorney to say, these are my documents, these are my assets, what is it that I have, and what changes maybe do I need? I have some people who come in and they don't know they have a trust, but then when I look at the deed to their house, I see that some years ago, the deed was transferred and a trust is the owner of the home. And sometimes the client doesn't even realize that that was what they had done in the past. And so it's very important to know those things. Who are the beneficiaries of the trust? So if we're creating a revocable trust, again, we're just avoiding probate. If I'm the creator of the trust, I'm probably going to be the main beneficiary throughout my lifetime of income and of principal. I may say that trust income and principal can be used for my spouse, maybe for my dependents, for other family members who are not dependent upon me. I might say that there can be charitable beneficiaries while I'm alive, but I can control that. In an irrevocable trust, for example, if it's a Medicaid asset protection trust, the beneficiaries are going to be restrictive. So, for example, if I create a Medicaid asset protection trust and I put my assets into that trust so that I can get protection around those assets in case I need Medicaid, to pay for some of my care, well, then I am not able to be a beneficiary of principal. Principal of the trust cannot be used to benefit me. It cannot be given to me and it can't be used for my benefit. So a lot of people don't realize that when they are creating these Medicaid asset protection trusts, they're really just taking assets and putting them aside so they can be protected to then pass on generally to the next generation, but certainly to the beneficiaries. They are not to be saved to be used for me. I can, however, be a beneficiary of income on a trust like that. So it can say that if I have a rental property in the trust, or if I have investments with assets or income, then I can receive that income, dividends or interest. I can receive that income. But again, the number one rule of keeping your trust healthy is knowing what the rules are and following them. So if I am not a permissible beneficiary of principal, then any distribution of principal that's made to me could spoil my entire trust. And so it's very important to follow that. Then the beneficiaries are likely going to change down the line. So upon my death, while I'm alive, maybe I get the income. If my children want, they can be beneficiaries of principal or some other person I choose to name, not a spouse if it's a Medicaid trust. But then upon my death, I then have further beneficiaries. So you can think about it as traditionally in your last will and testament, you would state who your beneficiaries are to receive your assets. You would do the same thing in a trust document. And that trust document would control how the assets that were in the trust were distributed at death. So who are the people that are to receive at death, and put those terms into the trust. And as I mentioned before, do those beneficiaries receive those sums outright, or do they receive them in some further trust? There's usually a time period after the death of the creator of the trust before the distribution to the beneficiaries, where the trust assets can be used to pay the final bills and expenses of the funeral or of the estate process, closing things up. Traditionally, the way an executor would use funds in an estate, but more quickly, the trustee has control of them as trustee of the trust. Then if I leave assets in a further trust to that individual, that testamentary trust we were talking about, again, the rules have to be stated. Who receives income? Who receives principal? Can they receive it for any reason? Are there limitations? And all of the limitations usually have a goal. So usually it's because we're trying to give our beneficiaries creditor protection or estate tax protection. So again, those are all in the document, and that document must be followed. This is the point where I tell everybody not to give their lawyer a hard time about boilerplate. Boilerplate is actually, if written properly into a trust, it is the language that tells the trustee what they can or can't do. And the more boilerplate you have, the more of that background information of how the trust is going to run, the easier the job is for the trustee because they know what to do. And the clearer it is what protections there are, because we know exactly what the trustee can and can't do. If you, for example, take your property and you put your primary residence into a trust, and let's use the example of this Medicaid Asset Protection Trust, then if it's a deed, you would have a deed that says Britt Berner gives her house to the Britt Berner Irrevocable Trust with some other person as trustee. It can't be me, it can't be my spouse, but it can be any other person. So say it's my child. So my child is trustee of the trust. Now, fast forward, I decide I want to sell the property. I want to move. I'm going to move in with my child. Well, my child can then sell the property, and the trust should have a bank account that reads the Britt Berner Trust bank account. And the assets, the proceeds of that sale will go into that bank account. And then what that money can be subsequently used for is going to depend on what the trust says the money can be used for, because we've now just taken one asset and converted it to a different type of asset. We took a house, we turned it into cash. Now that cash could be invested and it can be used in other ways. And then the rules of how it, when it can leave the trust is going to depend on the document. The important thing to realize is that if you do transfer your residence to a trust and then the residence is sold, the trustee will need to be present for the closing, and the trustee has to ensure that those checks are made out to the trust, not to the individual, and that they are then properly deposited into a trust bank account. You don't want to break the chain of those assets leaving the trust. Now, you may have an older trust, and so you may have done this planning some time ago. We generally recommend that people review their estate plans every 3 to 5 years, or if there's a major change either in their own circumstances or in the law. And so you want to be keeping up with what's going on, because that could signal a change that might be beneficial to you or to your loved ones or to whomever you're leaving the assets to, if you comply with that and make changes to the document. Now, in a revocable trust, I can change it however I want at any time. I'm generally not restricted in any manner. As long as I'm alive and have capacity, I can do what I want. In an irrevocable trust, whether or not you can change it and what you can change is going to depend on, again, what the trust says in terms of powers. What power do I retain, do I have as the creator of the trust that I can then use to change the trust? Generally, in a Medicaid trust, I can freely change the beneficiaries, I can change the trustees, and then for other amendments, there's usually ways that we can do it with consent of beneficiaries, etc. One example of a change that I've put recently into a client's trust. So I had someone who came to see me who did a trust many years ago. And it was when the estate tax exemptions were much lower. And they had to have they basically just understood that they were above those exemption amounts and they were going to have to pay taxes unless they spent down their assets. Well, now the estate tax exemption has gone up much higher. In New York State for 2022, an individual can leave $6.11 million without any estate taxes. And on the federal side, it's even higher. It's 12.06 million this year. Now that's going to change in a few years, but that's where we are right now. So this client came to me, and this existing trust that they had done with a different attorney was a very good trust for the time that it was created. But now fast forward, the assets have changed. She's gotten older and the estate tax exemptions have changed. All reasons why we had to review the document to see if changes were necessary. And one of the things that we decided we should do was add a disclaimer to charity. So what we can do in these documents is say that you have this $6.11 million New York exemption, but your estate is over that. It's about 6.5. Well, we can put in the document that if your beneficiaries choose to give the amount that you're over the exemption to a charity, then you can get back under the exemption and a lot less money will be lost to the beneficiaries and it will go to charity instead of to estate taxes. But in order for that to be done, we need to put language in the trust where the creator of the trust picks the charity and directs that any amount disclaimed by their beneficiary would go in that manner. Now, that's not appropriate for every trust and probably wasn't a proper planning tool when she first did her documents, but things have changed. So another part of keeping your trust healthy is keeping up on what's happening and how that may affect your estate plan and checking back in with your attorney to see, okay, are there changes that now require me to change my documents? And when I say reviewing your estate plan every 3 to 5 years or when there's a change, that doesn't always require a change in your documents. There might be a change in the law that doesn't actually change what you decide to do or how you decide to have your documents written, but it's important to know about and to find out if a change is warranted in your situation. An example of that is in 2020, we got the Secure Act. The Secure Act changed the way that beneficiaries inherit tax-deferred retirement accounts, like an IRA, for example. And so a lot of clients are coming in and we're advising them about it. For some of them, we have changed how the trust is drafted if their trust was the beneficiary of those retirement accounts. And then for others, we educate them about it, but it doesn't actually change what they decide to do with their assets. But it's an important conversation to have because it changes materially how your beneficiaries are going to inherit your money. Funding the trust. So an important part of keeping the trust healthy starts right at the beginning with funding. When I talk about trust funding, I'm talking about not just creating the trust document, which is the rules, but then actually changing the title on assets to put them into a trust. Many trusts have something on the back called a Schedule A. A Schedule A is a list of the assets that have been moved into the name of the trust. However, just putting documents on or just putting words on that Schedule A is not enough to transfer assets to the trust. You have to actually change the ownership. So as I said before, with a home, you would change the deed to the home to say the trust owns it. With a co-op, you would change the stock shares and proprietary lease to signal that the trust was the new owner of the residence. For a bank account, you would change the name on the bank account. For a brokerage account, a transfer of ownership, so that the statements would start coming in the name of the trust. And so you have to actually make those changes, and then importantly, keep track of it on the Schedule A. Now, you may have a changing Schedule A as time goes on. So some people, sure, they have a deed, they put the house into the trust, and they end up dying in that home, and that's the only thing that ever goes on the Schedule A. But for others, assets may be exchanged. Maybe it started out as a deed and they put a brokerage account, and now the securities have been liquidated and it was moved to a cash account at a different institution, or the house was sold and the money moved elsewhere. So keeping up with that Schedule A helps your trustee when they have to take over, especially if it's a revocable trust where they're taking over for you, but certainly a trustee who has to distribute after your death and handle the assets. It's helpful for them to have an updated list of what is owned by the trust, so that they can make sure that there are no loose ends, that they're properly closing up your estate. So funding the trust and then keeping up with your Schedule A is really important to keeping your trust healthy. Along with that, I would say, is checking on your beneficiary designations from time to time. So for example, as I said, with the retirement accounts, you may have your retirement accounts going all to your spouse and then to a trust for your children upon your death. Well, maybe as your children get older, you've changed your mind and you don't want the retirement accounts to go to a trust. You want it to go outright to your children. You can change that at any time. And it's important, if assets are going to be paid into your trust by beneficiary designation, that again, your trustee has a list of what those assets are, so they know to go out after your death and collect those assets and put them into the trust according to your wishes. And so again, it's that record keeping that's very important. We do recommend that trustees keep track of any transaction made on the name of the trust. Now, many trusts don't require an annual accounting by the trustees because it's a family member or maybe it's the individual themselves and they don't want to create unnecessary work. But that doesn't mean that assets should not be listed and that the trust document, it shouldn't be kept in a way where you know what is going to be paid into that. The other thing that we often like to put into trusts are a trust protector. So many times the trustee of a trust might be what we call interested. So the trustee is the individual themselves, the creator of the trust, or perhaps it's a beneficiary or somebody with some type of future beneficial interest or a family member. So a trust protector can provide an independent person who has the power to make certain changes in the trust, especially once the creator of the trust is deceased. So for example, changing the trust from being a New York trust to an Arizona trust if somebody moves and it's more beneficial to change the governing law of the trust, or changing or replacing a trustee if there's no trustees to act, naming a trustee to step in, or replacing a trustee who's not properly acting on behalf of the trust. You can also change, veto certain transactions. If there's two trustees, you can give the trust protector the power to be a tiebreaker. There's all sorts of powers you can give this independent person, which is not an ongoing job for that person, but can be a moment in which they step in and make a change to a trust to avoid having to go to the court to make those changes. And this can be any person who is independent of the individuals. So again, not a beneficiary. We don't like relatives. So some people choose their accountant, their attorney, another trusted advisor. Very often financial advisors can't serve in these capacities, but someone who is a trusted individual who could step in and assist if it was needed to avoid having to go to the court. I'm going to go over to the questions now because I know there have been some questions written in throughout. So let me just take a look at those. Okay. So there's a question here. If a house is in an irrevocable trust and is sold, do the proceeds stay in the trust? How are the capital gains paid? And is it by personal taxes or the trust? So my probably the answer that I'm going to drive home over and over again is it depends how the trust is written. Now, I'm assuming that this question is based upon a Medicaid asset protection trust, because that's what I was talking about when I was referring to an irrevocable trust. So typically, the way we would draft a Medicaid asset protection trust, which is an irrevocable trust, is as what we call a grantor trust. So if I'm the creator of the trust, I'm the grantor. And I would typically draft that type of document so that it was a grantor trust where it is mine for all tax purposes. So the deed to the property may say that my trust owns it, but when it comes to selling and capital gains tax and paying the capital gains tax and also determining what the capital gains tax is, it is based on my tax situation. And so it is not generally the proceeds of sale in the irrevocable trust for Medicaid purposes that is going to pay the capital gains tax. And then, yes, the proceeds would go into a trust bank account. There's a question about rental properties and making improvements on the properties. And again, it's going to depend on the trust document. And I'm going to refrain from giving detailed answers on that because there is difference from county to county in terms of Medicaid and how they see handling rental properties within a trust. So I'm going to reserve a more general answer on that. But generally speaking, the trust document is going to say that the creator of the trust is responsible for all maintenance and upkeep of a property, certainly of a primary residence. And with a rental property, it is a bit more complicated, but I would say to get some individualized advice on how to handle it in that particular situation. There's a question, how do I change a beneficiary of an irrevocable Medicaid trust? That, again, is going to depend on the trust document. You're going to hear me say that over and over again. But again, typically speaking, in that type of trust, we give the client what's called a limited power of appointment. And this is the power to change how the trust is appointed at death. So who is the beneficiary of that trust? And so that can be done depending on how the trust is written, either in a last will and testament or in a separate writing that's notarized, where you specifically say, I have the power of appointment according to this section of my trust, and this is who I want the new beneficiaries to be. But you have to be careful because the way the trust is drafted, if I have a power of appointment over a trust, that power of appointment might limit who I can leave things to. So in some circumstances, it's a more broad power, but then in others, it might say only to my children or my descendants, my children and their children, etc. So it depends on how the document's written, but usually it's done through a separate writing. If the house is in the trust, can they pay all expenses of the house? So again, it's going to depend on the type of trust and you have to look at the document. But in a revocable trust, yes, the trust can do anything it needs to. In that Medicaid asset protection trust, it's, as I said with the prior question or a few questions ago, that generally speaking, the creator of the trust is responsible for all maintenance, upkeep, taxes, etc. of the property. And so therefore the trust using trust assets to pay those things is seen as using money for the benefit of the grantor and is going to create a problem with the protection of the trust for Medicaid purposes. Okay. So it asks about, someone asks here about putting a retirement account in a Medicaid asset protection trust. We do not transfer retirement accounts to any trusts. retirement accounts are tax deferred. You take your required minimum distributions on those on an annual basis, or you might divide it by 12 or take it quarterly, however you choose to take it, but there's an annual amount for you to take. For Medicaid purposes, that retirement account is a protected asset. The required minimum distribution is just a stream of income. And so you would never move the retirement account into the trust. And a big reason is because you don't want that to be seen as a taxable event where you're taking a full distribution of your account and you have an enormous amount of taxable income. So you will leave that retirement account intact and only take the distributions that you're required to take. And depending on your county and depending on your marital status, you would either take your IRS required minimum distributions when you go on Medicaid, or the local Department of Social Services may choose to use a Medicaid chart. And so you would just look into your individual, how it's handled individually in your case. So it's asking if a trust can give a gift to a third party and then the party using it for whatever they want. So yes, they can use it for whatever they want. So if I'm the creator of the trust, I'm a beneficiary of income, but I can't receive principal, but I say that my child can receive principal, then my child can get that distribution of principal and use it for anything they choose to. It is their money. It is a true gift of money to that child, and it is their own at that point. There's a question here, who updates the Schedule A, a trustee or a lawyer? It should be the trustee who updates the Schedule A. In some circumstances, the creator of the trust may choose to do that because they're giving the asset to the trust, so they may keep a list of what they've given to the trust. But it's the trustee who should keep track of that. Because every time you put an asset in the trust, it doesn't necessarily require action by an attorney. For example, if you're going to go put a bank account into a trust, there's nothing the attorney needs to do as that transfer because the trust is already created and you're just taking the trust document to the institution or bank and opening up that account. So there's a question here about a revocable trust and if it could be funded by being named as beneficiary versus owner. So yes, in some circumstances, someone may choose to leave an account in their own name while they're alive, but then state that upon their death, the account lists a beneficiary and that beneficiary is the trust. And in some circumstances, that's appropriate and people do that. When you create a trust, you should go through each asset individually with your attorney in order to determine what's going to go into the name of the trust now, what's going to have a beneficiary, what will have individual beneficiaries versus trust beneficiaries, etc. There's a question here, what if the house is in a revocable trust? But I'm not sure what it's referring to, but that will avoid probate at the death of the individual on that house, because if that house is in someone's individual name, then upon their death, the probate of the will would have to happen to determine how that asset will be distributed. But if it's in a revocable trust, it avoids that process. And for Medicaid asset protection purposes, a house being in a revocable trust will save Medicaid from putting a lien on the house after death, because if we avoid probate, we avoid Medicaid as a creditor. But then depending on which type of Medicaid the person's applying for and certain other exceptions that apply, whether or not that house would be protected on the eligibility side is going to be determined on a case-by-case basis if it's in a revocable trust. So there's a question here, if you don't set up a trust but have beneficiaries, what's the possible problems that will arise? So again, all of this is very person specific. So it's not appropriate for everybody to have a trust. One concern that I have, if somebody has a bunch of different bank accounts and they all name different beneficiaries, and so they're all getting split up immediately at death, then there's no one who is in charge of the estate. There's no one whose responsibility it is to make sure all of the final expenses are paid, and the money is just basically gone out to the beneficiaries. And that is especially a problem if it's a taxable estate, if it's over those taxable amounts. But also you might have a rental apartment or home that you live in that needs to be cleaned out, and there's no money in the estate for that property to be cleaned out. So those are some of the potential problems, is when you don't have that central pool of money. Also, if you're looking to protect your future beneficiaries with any kind of trust, if you just name them individually as beneficiaries, you're not able to protect them in any way. There's a question about someone who is a joint owner on a primary residence with their parent, and asking if the residents should be put in a trust for Medicaid planning purposes or not. And what I would say is that is a hard thing to answer as a general question. A lot of times, whether or not to put a property, be it a co-op or a condo or a primary, a home, a freestanding home, into a trust is going to depend on the specific factors of those people. So I think that's a hard one to answer in a vacuum. So does the capital gains exclusion 250, 500K apply to the post-death sale of the property in the trust? So what this person is talking about is, if I'm an individual and my primary residence, which was my primary for 2 of the 5 years prior to sale, it was my primary, and that property has gone up in value, $250,000 of that is excluded from any tax. So for example, if I bought a property for $10,000 and now it's worth $250,000, there's a gain of the $240,000, but because I have a personal exemption of $250,000, I would not have to pay any capital gains tax on that property. If the $500,000 is if it's a couple, there's 2 people. Upon my death, that property gets what's called, if I still own it, that property gets what's called a step up in basis. So if upon my death, it's worth $250,000, and then my trustee sells it for $250,000, whether it's the trustee selling it or if I kept it in my name and it's sold from my estate, either way, as long as it's the grantor trust. So usually these Medicaid trusts we're talking about, and certainly a revocable trust are, either way, that step up in cost basis happens and there would be a capital gains tax. But you don't get the $250,000 exemption after death. That is your lifetime. If you're alive, that's your exemption. It's actually a better deal. You get that step up to your date of death value if it is transferred or sold after death. But yes, that would apply in the type of trust that we've talked about today as well. Can a trust help you avoid being placed under a guardianship? It's certainly a step in the right direction, because it's you providing for the management of your assets and your finances if you're unable to do so. A guardianship in New York, an Article 81 guardianship for an adult who loses mental capacity is supposed to be look for the least restrictive manner in which to manage your funds and your assets. So if you have an individual who loses their mental capacity and their money is being handled by a trustee who's doing a good job and not mismanaging anything, and they have a healthcare proxy to manage their healthcare, then there might not be a need for a guardianship, because everything's taken care of. There are no powers that a guardian would need. So a trust is definitely a step in the right direction. Dollar ceiling on a gift from the trust. So the trust, the gift taxes, regardless of if I'm giving a gift or if my revocable trust is giving the gift, or if my irrevocable Medicaid asset protection trust is giving the gift, this year, the federal gift tax exclusion amount is $16,000. So that means that I can give everybody on this webinar $16,000 and not have to file a gift tax return. However, realize that if I give everybody on this webinar $20,000, $4,000 to each of you is considered taxable, but that goes against my lifetime exemption, which, as I said earlier, is currently 12.06 million. And after 2025, starting in 2026, it will be 5 million indexed for inflation. So it might be a red herring. It might be just a tax reporting requirement, not an actual tax that would be paid. Principal as opposed to income. So income is if there are net proceeds from a rental of a property. And so generally the trust would read that the income comes into the trust, it pays, whatever has to be paid for the rental, for example, and then the net proceeds go out. It depends how the trust reads. Principal would be a bank account, an investment account, but the interest and the dividends on any of those stocks, for example, that would be considered income. So everything either falls into one of the two categories. Revocable trusts do not provide any creditor or lawsuit protection. That's a question on here. So there's a question about whether or not somebody wants if somebody wants to leave an inheritance for their child in a trust, should they do it through the will or should they do it now? So again, you'll probably want to get personalized advice on this, but as an example, if I say I'm going to give my entire estate to my child and my will says everything goes to my child in a trust, then upon my death, my will has to go through probate. That process can take some time. That trust is created as a result of that probate process. The letters appointing the trustee have to come from the surrogate's court. If down the line the trustee has to change, you have to go back to the court to get that changed. The other option, which I think is a better option if you are going to have a continuing trust like that, is to create a trust now for yourself, even if it's only a revocable trust, and then have your revocable trust state that everything goes to your child in a further trust. And then that will be administered completely free of the courts and in a private manner and not be part of the surrogate's court process. So that's generally better. Okay, great. Well, thank you everyone for joining us. I think this was a great conversation. I appreciated all the questions. And again, keeping your trust healthy, most important things, know what the trust document says, know what assets are in the trust, and know who can receive what and what you can and can't do. And if you know the rules and you make sure you follow the rules, your trust will remain as healthy as possible. Thank you, everybody. Enjoy the rest of your summer, and we'll see you soon.